Hello, Central Florida, and welcome to Around the House, sponsored by Romac Lumber and Supply. I'm your host, Don Magruder, and you're listening to my 790 AM WLBE in beautiful Leesburg, Florida. Now, if you're watching today's show, it's being seen on LSTV, that's Lake Sumter Television, courtesy of Red Apples Media, on Comcast 13, Bright House 498, and Florida Cable number 4. Romac Lumber's leading provider of building materials in Central Florida, and since 1945, local residents have come to depend on Romac Lumber's expertise. With locations in Leesburg, Mount Dora, the Villages, and Ocala, Romac Lumber has Central Florida covered with all the structural components you will need for your doors, windows, garage doors, roof trusses, and a full line of building materials. We have a great show lined up today. In our second segment, I'll be talking with Dave Pierce from Dry Right Emergency Services about water and mold remediation issues around the house. This is a big deal in the state of Florida. In my first segment, I have a great guest, Miss Arlene Udick of the Udick Law Firm in Lady Lake, and we're going to discuss why it's important to review all your real estate transactions with a competent real estate attorney. Unfortunately, every day people make serious mistakes when buying or selling a home because they did not have an attorney review their transactions. With that, good afternoon, Arlene. How are you doing today?
I'm doing great, Don. Glad to be here.
Well, we're happy to have you because it seems like we're in a litigious society, and every day something's under contract or something's disputed. So we're very happy to have you. And I guess I better say before we get started, the following segment is a general discussion on legal issues, and it may or may not apply to your situation. Please consult your attorney before taking any actions based on today's discussion. That's sort of our legal disclaimer. We're going to have a general discussion, but once again, you need to talk to your attorney if there's a matter specifically involving your property or house. Arlene, with that, take a few moments. Tell us, where does the Udick Law Firm practice law? And if someone had a question about something you heard today, how can they contact you?
Well, my areas of practice, the geographical areas, are between Leesburg and Ocala. I do have a client out in Washington State that I've known for years, and I've done legal work for years. And with the internet, it's pretty easy to have clients, that are not in your backyard. But generally, I practice around the village area between Leesburg and Ocala.
And you have a website that I think is pretty neat. What's your website address?
My website address is www.udicklaw.com, and I'll spell my last name because it's a little tricky. Of course, my first name is Arlene, which is Arlene. Last name is Udick. U as in umbrella, D as in dog, IC as in ice cream, K as in kettle, LAW.com.
And it's a good website, got good information about what you do. First thing, let's talk a little bit about your background and experience because it's quite expensive. How did you get in law, and where are you from, Arlene?
Well, actually, I was living in New Hampshire. My children went into puberty. I couldn't stand it, so I went off to law school. I've been practicing for 29 years. I'm licensed in Maine, New Hampshire, and Florida. And before I came to Florida, I worked for T-Mobile, and I managed the Northeast Legal Department from Maine down to North Carolina, and we supported operations and engineering. So basically did a lot of real estate, a lot of leases, a lot of funky contracts. I've done contracts with satellite companies after 9/11. I've done the contracts for the George Washington Bridge, the Lincoln Tunnel, the Holland Tunnel to put up cell sites, switch hotels, like a 50-story building in Lower Manhattan that has all switches, which, when you talk about it, people's eyes glaze over, but I think it's really interesting. So I came to Florida to get married. I met a man, and my husband's retired, and I try to be retired, and it just didn't work. So I worked for the Villages for a couple of years, in the commercial property management department. I did retail leases for them and other projects that they had. And I really missed the law. So 2006, I took the Florida bar with about 2,000 people who were younger than my kids, and passed it on the first attempt and opened up my own office in 2007. And the first 2 years, because I wasn't a Florida attorney and didn't go to law school here, first 2 years I had about 287 CLE credits just to come up to speed in real estate and commercial law. I'm also a member of the Executive Council for the Real Property Probate and Trust Law section, and I sit on the Landlord-Tenant Committees, the Construction Law Committee, Commercial Real Estate, and the Real Property Litigation Committee. And these are the committees that draft legislation for real estate and probate law, and the committees that teach other lawyers. We have CLEs, and we teach other lawyers. And for 2 years, everybody around here uses the FAR bar contract, the Florida Realtors, Florida Attorney contract. It's drafted. I was on that committee for 2 years, and we updated the committee for 2 years.
So you have extensive knowledge, not only in the state of Florida, but other states about legal matters. In fact, you've done some big deals. So you're down here in Florida now, and you're writing contracts, and you're handling commercial law. Let's specifically talk. What type of law do you specialize in, Arlene? What's the scope of your work?
The scope of my work is commercial law. I do formations, LLC, and corporations. I work with investors who are invest in properties. I do notes and mortgages, contracts. I do private consults for clients. They don't want to hire an attorney to work on an issue, but they need to meet with me once to go over a contract. So I do fee-based consults, and I do a lot of medical leases. Not as many as I did a few years ago, but I did a lot of medical leases. Did a lot of work for the doctors when they build their buildings. Like, you negotiate with the seller of the land, you negotiate and contract with the architect, the general contractor. You do medical leases, and I have several doctors for clients. I do office sharing agreements for doctors and dentists and medical people. Let me just look through this. To me, you take it for granted because you do it every day. I do residential and commercial contracts, the buy-sell contracts.
Right.
I also represent buyers and sellers in businesses, people who want to sell a business. Also, right now, I'm working on an article on the new brokerage law for horse sellers, for people who are selling horses. And I've just recently written an article for the Bar magazine, the Real Property Bar magazine, on private money lenders and Dodd-Frank.
And the thing about private money lenders, that's, a lot of people said, because of the complications in getting financing, there may be an opening for private money lenders.
Well, Dodd-Frank has made it so onerous that I would say stay with a professional lender, because Dodd-Frank has a 2-year clawback that if you don't comply with the provisions in the law, if you're a private money lender for a residential property, there's a 2-year clawback. So all the money your borrower paid to you, you have to give back if you don't follow the provisions.
Wow. Well, I've talked to several bankers lately, and I don't want to go on a different rabbit hole, that the problem remains in housing. Ordinary people can't get lending, and in the next month, so they're going to make Dodd-Frank even stronger and more odious, and a lot of people just can't get through the hoops of financing. It's just too many roadblocks.
Right.
And that's one of the reasons why you should hire, why they should hire an attorney, I'm assuming. But in your view, why should someone hire an attorney?
Well, if you're going to spend a couple $100,000 to buy a property, why wouldn't you? I mean, most attorneys will do a flat fee to represent a buyer or a seller. And, well, one of the major problems I see are the deeds. The deeds that are drafted don't comply with Florida law. So because of the homestead, and there has to be a constitutional homestead. There's recitation of the marital status and the homestead status in every deed, and a lot of people use their attorney from wherever they came from to draft these deeds. We love it. I love it because it's more work for me, cleaning it up, but it causes a serious problem, and it can be very, very expensive.
Well, a couple things you mentioned, I think we need to clear up. You're not an accident attorney that works
No.
that works on a contingency.
Right.
So if someone calls you for information or advice or help on a legal matter, there is no free consultations like a accident attorney, correct?
Correct.
So
I do charge for consults.
And then the other thing is, you've said it a couple of times or alluded to it, LegalZoom.com, let's say an online website, is probably not the best place to get your legal advice.
Correct.
Because the laws are so different in every state.
Well, let me tell you my personal experience. When I moved here, I had already been practicing real estate for 20 years.
Yeah.
I knew everything there was to learn about real estate. I didn't know anything about Florida real estate. About 2 or 3 years, I drafted the deed for when my husband and I were married, transferring the house to both of us. I didn't know Florida law then. After I took the bar, I realized I didn't do this correctly. It didn't comply with Florida law, and I had to redraft the deed again. So even there's a lot of traps here for inexperienced real estate attorneys.
And young attorneys who may not
Yes.
know. I want to talk a minute about contracts. Isn't it true contracts are usually written in favor of the person who writes a contract?
That's why I always like to write the contract for my clients. Yes.
So
Yes.
So if someone writes a contract, it's going to be written in favor of your. For example, if you wrote a contract today for a client, the contract's going to be written in favor for your client generally, correct?
Absolutely, 100% of the way. And it's to your client's advantage to have you. Costs a little bit more money, but it's to your client's advantage to draft the contract because it puts the other side on the defensive. Now they have to come back and they have to ask for changes and they have to ask for concessions and they have to ask, and it puts them in a very defensive position.
You're listening to Around the House, sponsored by Romac Lumber. We're having a great discussion with Arlene Udick. She's an attorney out of Lady Lake, and we're discussing real estate law and contracts. And it's just a general discussion, no specific information. If you have a specific question, please consult your own attorney. All right, we were talking about contracts, and a contract, if you write it, it's going to be in favor of your client.
Yes.
So if I'm someone and I get a contract from a party and I don't hire an attorney, but yet these other people have gotten an attorney to write a contract and it's written in their favor, it almost seems unfair, doesn't it? Unfair if you don't hire your own attorney to review it.
Well, exactly, because you take whatever they give you, and it may not be in your best interest, or you may not be able to perform what's in there.
And something about contracts that I think needs to be brought out, because I've dealt a lot with contracts, but you have a right, you're obliged to mark up a contract. Someone gives you a 10-page contract and it's all perfectly typed. You can take your old-fashioned ink pen and mark out and change words and all that to that you don't like. Talk a little bit about what that does to the contract, but the ability to do that itself.
Absolutely. Before the contract is signed, you need to negotiate the contract. You should never ever take a contract and just accept whatever they give you. You need to negotiate what works for you, what you feel comfortable with. You need to look at the contract and see there's always some risk for something. How the risk is allocated depends on the contract. The construction contract has more allocation of a risk than, say, a purchase of a house that's already built. So you need to look at where your comfort level is, and before the contract is signed, you should absolutely mark it up and negotiate all the terms. I mean, that's why they present it to you. Once the contract is signed, you have a binding contract, and if you mark it up, you have to be aware that now you've changed the contract and it's a new offer to the other side.
And you said something real important there, Arlene, about marking up the contract and negotiating before the contract. I found in most cases, people draft a contract before they do negotiations in hopes that you accept the contract as written, when you should not, and you should mark it up. So the problem is when you're given a contract and you've never had an opportunity to negotiate, that's sort of the root problem, isn't it?
That's the beginning of it. I would also suggest when somebody looks at a contract, make an outline, especially if it's longer than 5 pages, because you want to get a general view of what's in that contract. When I do, especially retail leases or long leases, I always make an outline so I get an overview of what's in there and what I think I need to have in there.
How do you advise someone from not being intimidated through the contract process, where they are free to mark up contracts and realize this is just a typewritten document, but I can mark it up with an old fountain pen any way I want?
Mm-hmm.
How do you advise people to get over that hump?
Well, they have to look at it. It's business. It's nothing personal. You know, you're not going to hurt the other person's feelings. You have to have in there what you need, and if you can perform the contract. And if you can't perform it, and maybe that's where people get intimidated, is because they know they can't perform it, so they're afraid to change it.
So, great advice. Let's talk about some of the legal issues in the contract. You know, there are a lot of words, stipulations, and phrases which make up a contract, and it's amazing how one word can change a different. For example, we talked off the air, shall and may be. The difference in you shall do this and you may do this. Describe the difference in those two terms.
The word shall is mandatory. That means you must perform. May means you can if you want, but it's not necessary for you to do that. Things like A and B, as opposed to A, comma, and B, have two totally different meanings.
Right.
So you really need to look at a lot of the grammar and a lot of the structure. I see contracts that come to me that are drafted, some by attorneys, some by lay people. I have no idea what they're saying.
So if you don't have any idea what they're saying, you need to reword it in your own words to make sure it's understood, correct?
Exactly. And I think maybe the language intimidates people.
From a buyer's perspective, what are some of the issues when buying a home or a piece of property they should be watching out for?
Well, it depends on who. You asked about a buyer specifically, so I will answer this question for buyers. Number one, a lot of the contracts, including the FAR bar contract, you need to do your homework and you need to do your due diligence, and you really need to have an inspection.
Okay.
And you need to do, I do it now, and a lot of the firms do it. It's a municipal lien search.
And what's a municipal lien search?
Well, like in the city of Leesburg, they provide water.
Yes.
And if you don't pay a water bill, they'll put a lien on your property, but they don't record it at the Registry of Deeds and the official records.
So, for example, a city that has code violations, maybe you didn't cut the grass, or the house was vacated and the city cut the grass and put a lien on for $300 for cutting your grass.
Exactly. And interest is running. If you don't check out those code violations before you purchase the property, you inherited it.
And what about open permits?
That's another problem, is that sometimes the contractor doesn't close a permit. Sometimes they've never had the final inspection. The house may have been transferred 2 or 3 times in between, and that permit's still open. So now you want to put an extension on your house, or you want to fix it up, you go pull a permit. They say, no, we can't give you the permit until you close this. Well, the code ordinance may have changed over the years, and now you have to do upgrades, you have to do hurricane, whatever they require.
Arlene, one thing I've also noticed on contracts, we've talked about a lot of wording and stuff. Many contracts have bad math on it. They'll have the wrong amounts for the withholdings amount, or not withholding, but the various fees and stuff. People should really scrutinize the amounts and question these charges on contracts, because a lot of times they're getting intimidated with these cost amounts, thinking they have to accept them.
Oh no, they're all negotiable.
Right.
Who pays that cost? That's all negotiable.
While we're talking about typically, what does the seller buy? What does the seller pay, and what does the buyer pay in a regular residential contract?
Okay. Generally, this is standard. I can't tell you what I charge, because that could be construed as collusion.
Yep.
However, if a broker comes in, they bring the contract, they It's the broker prepares the contract, so there's no fee for that. But if there's no broker, if it's a for sale by owner, there's a fee to prepare the contract, and there's a fee to prepare the deed, which is generally paid by the seller. There's a fee for the title search in Florida. The seller pays for that, and they also pay for the owner's title policy.
Okay.
If there's any financing involved, it's the borrower that then pays the bank's or the lender's title policy. The doc stamps on the deed. The recording fee is paid by the buyer. The doc stamps on the deed are paid by the seller. And that fee is 70 cents per $100 of consideration.
Okay.
And consideration can either be whatever you paid for the property, or it would be what the money you paid. And if you're assuming a mortgage, then you pay on that. And then the buyer pays the doc stamps on the note and the intangible tax on the mortgage. And then if there's any settlement fees, any home inspections, generally the settlement fees are split between the buyer and seller, however the office charges, and if there's a home inspection.
One thing you mentioned is title insurance. I understand title insurance is not mandatory in the state of Florida, but it's something that's probably advisable, isn't it?
Absolutely. Absolutely.
Why is title insurance important?
Well, it could be, as I said before, a lot of times, especially people draft their own deeds, or attorneys from out of state will draft a deed, and it doesn't comply with the Florida requirements for homestead. And all of a sudden you have a spouse that still has an interest in the property and may have transferred hands a couple times. The title insurance will take care of that and insures the titles against defects through the chain.
And if someone intentionally withholds information during a real estate transaction, for example, they're asked a checklist, do you have this, what's any recourse on that? For example, if they don't disclose a problem with a property?
Well, the sellers are supposed to fill out a seller's disclosure statement.
Right.
And it asks, do you have mold? Is there water? And do you have flooding? Things like that. And generally the standard used to be buyer beware, caveat emptor, but no longer in Florida. In 1985, the Florida Supreme Court passed a seminal case called Johnson v. Davis. And what that case stands for is that the seller has to disclose all known latent defects. I mean, if it's really obvious that the ceiling's fallen apart and you can see that, then there's no liability. But if the seller knows or neglects or forgets to put it in the seller disclosure statement and knew at some point it was there, they're liable. The courts won't rescind the contract, but they will cause the seller to pay for the remediation to fix it.
What's the biggest mistake both buyers and sellers make when they buy or sell a real estate property?
I think a lot of times, I could speak for the buyers, they don't want to spend the money for the due diligence.
Okay, in other words, they don't think they need to get the inspections done.
They don't need a survey, they don't need the inspection. I mean, you need to have a survey, you need to know what you're buying.
And real quick, we just have a few moments. Leases are a big thing. A lot of people just willy-nilly sign leases, but you really should have a lease looked at, shouldn't you?
Absolutely. And one of the biggest problems with residential leases and commercial leases in Florida, if the term of the lease is beyond a year, you have to have 2 witnesses.
Wow.
Otherwise, you don't have a valid lease.
Well, Arlene, this segment's gone by fast. You've given us a lot of great information. One, real quickly, if someone wants to call you, what phone number can they call you at?
352-391-1888.
I want to thank you, Arlene, for being our guest today. Great information. And when we return, we're going to talk to the folks at Dry Right about mold and water remediation. See you in a moment.